Today, I'm going to explain the concept of ostensible agency in the context of malpractice lawsuits against hospitals, particularly under California law. This is an important legal principle that can hold hospitals accountable for the actions of physicians, even when those physicians aren't direct employees. So, what is ostensible agency? It's a legal doctrine that allows hospitals to be held liable when a patient reasonably believes a physician is acting on behalf of the hospital. This applies even if the physician is an independent contractor. Under California law, specifically Civil Code sections 2298, 2300, 2317, and 2334, patients must prove two key elements to establish ostensible agency. First, the hospital must have held itself out as a provider of care. This can happen implicitly or explicitly through the hospital's branding, signage, or operations. If the hospital doesn't clearly inform the patient that the physician is not its agent, it may face liability. Second, the patient must have relied on the hospital for care, not the individual physician. This means the patient sought treatment from the hospital itself, not because they specifically chose that doctor. If the patient personally selected the physician, the hospital may not be held liable. Now, how do courts determine if ostensible agency applies? Generally, courts presume the hospital is liable unless one of two things is true. The hospital explicitly notified the patient that the doctor was not its agent, or the patient was treated by their personal physician, showing they knew the physician's independent status. Let's look at some key California cases that clarify this doctrine. In Markow v. Rosner from 2016, the court outlined the two-element test I just described and emphasized that reliance is shown when a patient looks to the hospital for services. In Wicks v. Antelope Valley Healthcare District in 2020, the court reinforced that hospitals may be liable unless they clearly notify patients of a physician's non-employee status. Whitlow v.'s Rideout Memorial Hospital in 2015 added that courts may consider whether the patient entrusted themselves to the hospital and reasonably believed the physician was an agent. Finally, in Mejia v. Community Hospital of San Bernardino from 2002, the court stated that a patient typically only needs to show they sought treatment at the hospital. The issue of ostensible agency then goes to the trier of fact, unless there's conclusive evidence the patient knew the physician's true status. There's also another way to sue a hospital, even if ostensible agency doesn't apply. In Elam v. College Park Hospital from 1982, the court held that hospitals have a duty to exercise reasonable care when granting privileges to physicians. This applies to all doctors using the hospital's facilities, not just employees. If a hospital knows or should know a doctor is unqualified but allows them to practice, it can be held liable for negligence. This case underscores that hospitals, through their governing boards, have ultimate control over who can use their facilities and must prioritize patient safety. In summary, ostensible agency is a powerful tool in malpractice lawsuits, holding hospitals accountable when patients reasonably believe a physician represents the hospital. The Elam case opens to the door to lawsuits when a doctor is allowed to practice at a hospital when a danger to patients is clear.
Daniel Horowitz is a highly respected lawyer involved in medical law. He is also a noted television legal commentator, law professor, and trial lawyer. You can reach Daniel at 925-283-1863. Thank you for watching our video.